Well, I've been given the honor of introducing two people that I've been working with since the beginning of Idle No More. Russell and Art are both great thinkers in the fields that we're talking about this weekend, and also activists and part of Defenders of the Land. And Idle No More has been working with Defenders of the Land since January, and so they have become our teachers in their expert knowledge, and they have become our mentors as we work through how to move forward with Defenders of the Land and Idle No More. And so I'm going to start by introducing Russ, who's a member of the Mohawk Nation of Ganawaki, and he is also known on Twitter as Truth Bombs Diabo. And so I know today we're going to be getting some truth bombs from him, and I'll ask him to come up and give you a little bit more information.
Thank you. Good afternoon. I'm glad I got to come and listen to the whole conference when I was invited. I want to thank Rama for being on their territory as well. And I want to thank the organizers for inviting me. And I'm glad I decided to attend the whole thing rather than just coming in and out for this panel, because it gave me some of the context of the thinking that the other speakers and panelists have had on this subject, which is a complicated one. And I have to say, I have differences of opinion, respectfully, with what Roberta said. She gave kind of a selective chronology, and of course the other speakers, some of them which I agreed with, but what I wanted to do in my session was to kind of give my own chronology and talk about what I think is going on now. Because I don't know more in Defenders of the Land. We have an alliance and we have a campaign, and I'm going to talk about our demands. I'm going to end off with those. But I wanted to give some context to them. And I guess where I would start is, Canada bases its assertion of sovereignty on the doctrine of discovery, which is a racist, and the doctrine of terra nullius, empty territory. In Quebec, that's what they used. They said in Quebec, the lands were uninhabited by people because they were savages. And in England, in Newfoundland, they just planted a flag. So, you get Jacques Cartier sailing up, what's now known as the St. Lawrence River. You get John Cabot landing at some say Bonavista, Newfoundland. And then you get Champlain, then you get other explorers, Captain Cook and BC and others. And, this is what Canada has always kind of, the Imperial Crown has kind of had a mask. They needed us as military and trade partners early on at the time of contact. One of the oldest treaties between Europeans and indigenous peoples in North America is the Turo Wampum. I think that was mentioned earlier by somebody asking a question. And that was in the 1600s with the Dutch. And that relationship was with the Haudenosaunee, the Iroquois Confederacy. And it evolved, with the British after the Dutch. And it evolved into what was called the Covenant Chain relationship. But it came about through a series, fights between the French and the British. And, it was in 1760 that the British made peace and friendship treaties. There was a Treaty of Oswegatchie up along the St. Lawrence River, not too far from what's now Cornwall or Arkwazasni. And then there was another Treaty of Ganawagi, where they agreed to remain neutral when the British went to attack the French in Montreal, and of course defeated them, and then later on in Quebec City. Before that, we were allies with the French, but in 1760 we changed. We said we'd be neutral. Then through the treaties, we made a partnership with the British. And those 1760 peace and friendship treaties, because we were a military threat, so they wanted to make sure we were friends and allies, led to the Royal Proclamation of 1763. Which set out the rules. Other people have mentioned it. Indians couldn't sell the land to anybody but the Crown. And that's where the fiduciary trust responsibilities came in, because the Crown was supposed to protect our lands from trespass. And that was further reaffirmed in the Niagara Treaty of 1764, which I think is one of the more significant treaties, because it set the stage for the treaty making after that in Ontario, and then the number of treaties in the West. And the treaty relationship, where we were allies, treated, pretty much as equals, went on until about the war, after the War of 1812, because in the War of 1812, who was at the front lines? It was the Indians. Otherwise, you'd all be Americans now, because the Canadians were behind us. They had our back, I guess. But I've heard it said that at least 7,000 Indian people died in the War of 1812. That's a figure that I've heard. I do know that there were many, many who were involved in that conflict. But when the British Loyalists started moving up into Canada and they started making treaties in Ontario, Robinson treaties, we started to get outnumbered. And as the demography changed, that's when we ceased to be a threat in terms of a military threat, and the alliance that we had through the treaties started to change. These new settler governments started to pass laws, pre-Confederation laws, which after Confederation of 1867, in 1876, they consolidated the pre-Confederation laws into the Indian Act. And the Indian Act had two main objectives. One was to protect Indians from advancing settlement, but the other was to assimilate Indians into the body politic of Canada. And those were schizophrenic objectives, and they're still in place today. The Act has been amended from time to time, but it's still there. And basically, my thesis is that Canada has a war on First Nations. It's not a conventional war, but it's a war on our collective rights. The Indian Act was designed to assimilate us. It only had one way. It didn't have reverse. It was to move custom governments into Indian Act governments. Chuck Straw did it with Barrier Lake. He was mentioning it's okay to be under custom governments. He didn't mention that he used Section 74 in 2010 to force one of the last custom bans in Canada under the Indian Act elective system. Because under that section, the minister has, if he decides it's best for the band, he can put them into the elective system. It's a rarely used section. They used it in Six Nations in the 1920s. But, the Indian Act is used to control and manage Indians, to assimilate them, till they were fit for citizenship, what they called enfranchisement. That was the purpose of the Indian Act. And like I say, it was first developed in 1876. You keeping track of my time? And then, it's still in place today. In the 1920s, they amended it to make it illegal for Indians to hold ceremonies, to hire lawyers, to defend land rights. That's when the RCMP took a lot of our material culture from, all the nations across the country. That's where they had Indian agents watching us to make sure we weren't holding meetings without their consent. That's when they padlocked the longhouses in Six Nations and put in the elective system and put out the longhouse. And then they did that with other Iroquois communities as well. That's why today you have kind of competing governance systems in the Haudenosaunee communities, because, the longhouses are still governing through the traditional systems, and you've got the Indian Act elective systems recognized by Ottawa and funded by Ottawa. And they've done the same with other groups across Canada. Now, there's been a number of studies. Roberta pointed to some of them. The Penner Report, that one said that, First Nation governments should be accountable to their people, not to Ottawa. That was in 1983. It was a special parliamentary committee on Indian self-government, just after the Constitution Act 1982 was shiny and new. They recommended that First Nations should be recognized as a distinct order of government in Canada. That was put on the shelf by a Liberal government. And, following that, the Mulroney government came in. Well, let me back up a bit. The 1969 White Paper on Indian Policy was referred to, which was a policy to basically get rid of the Indian Act and get rid of Section 9124 that references that the federal government's responsible for Indians and lands reserved for Indians. So in other words, to erase any legislative or constitutional references to Indians, basically assimilate them in as municipalities, turn them over to the provinces, end the treaties, basically maintain the underdevelopment the Indian Act had created. And those objectives, they publicly said that they were being withdrawn, I think around 1971, but I have a letter from an assistant deputy minister from around 1971. It wasn't Scott Searson, it was somebody before him. But they said that the objectives were sound and that they should stop talking about them publicly and just talk about them as components. So in other words, to continue implementing the white paper, but do it in pieces. And that's basically, if you look at the administration of Indian Affairs after that, you can see that's what's been going on. And that's why I was disappointed when Roberta was asked if there was a plan to get rid of, eliminate First Nations in Canada, and she said no. Well, I know she knows better, because there is. And it's been from the white paper. It's what I call a termination plan. And I use the word termination because that's an American policy used on Indians down there. The termination policy was to get rid of the tribal status of Indians in the United States. They did it to the Menominee in Wisconsin. They were a thriving economic community. Once their status was taken away, their economy collapsed. They lobbied to get back. That was in the 50s. It took them until the 1970s. Richard Nixon reinstated their tribal status, ironically. And the reason why I referred to termination was because of Tom Flanagan being an American coming up here trying to import American Indian policies into Canada. So I started using the term termination plan, termination tables. Because all the things that I've seen over the last 30, 40 years, and I have been around observing all these things. I was at the constitutional talks in the 80s and that. Around Section 35, the war that I'm talking about that Canada is doing is to empty out the legal and political meaning of Section 35 of the Constitution by coercing, Indigenous groups into agreements that water down and compromise their constitutional rights for far less than what they're entitled to. And since Section 35 was passed some 31 years ago, starting in, they had the constitutional talks in the 80s to identify what Aboriginal treaty rights were in the Constitution. Those ended in failure. So that legal and political uncertainty of Section 35, the federal and provincial governments have been taking advantage of that. And the feds have developed what they call self-government policies and land claims policies, which they say those are negotiating policies to negotiate your way out of the Indian Act. If you want land, you have to go through land claims policies. If you want to get out of the Indian Act from governance, you have to go through the self-government policy. The inherent right policy, which I mentioned to Paul Martin. That policy is basically to turn bands into municipalities. Some have agreed to do it. There's an organization that was formed from the ones who signed modern treaties, from the James Bay Cree, the Nisga'a, the Yukon First Nations, and others. They created a different organization from the Assembly of First Nations. It's called the Land Claims Agreement Coalition. And the reason why they created that organization was because these modern treaties weren't being honored by the federal government. They weren't being implemented. And so they came together to lobby the federal government to implement these modern treaties. Yet they're trying to convince others who are at these negotiating tables that it's a good thing, and even those who haven't gotten into them yet that it's a good thing, when they don't even honor them after they're signed. And if you look at the comprehensive claims policy, which is what these modern treaties are based on, it's to extinguish Aboriginal title so that the Crown can get clear title. Meanwhile, you got the Supreme Court of Canada in 1997 setting out legal principles that Aboriginal title exists in Canada, but they never said any one particular group has it. So what First Nations are faced with is, if you think about it, think about a blanket being across Canada over all the 633 bands in Canada, and each one of them has to cut their way out of that blanket. Because I've heard about amendments to the Indian Act, we should do this and that. But I don't believe a top-down approach will work because everybody's blanketed by the Indian Act, but each band has its own facts about whether they embraced it or resisted it. You know, some feel comfort under that blanket because that's all they know. Some think that's where the rights come from. So it's got to be from the bottom up, those changes. You know, and I think it has to be broad recognition that the right to self-determination and the right of self-government is there. Section 35 says Aboriginal treaty rights are recognized and affirmed. But the policies are avoiding and denying that those rights exist. And what the feds say is, we're prepared to exchange your undefined rights for some defined rights. And in the process of that transaction, you're agreeing to watered down rights. Because the courts have said, you know, you've got pre-existing sovereignty, you know, versus, that's the purpose of Section 35, is to reconcile the pre-existing sovereignty of Aboriginal groups with the sovereignty of the Crown. I say the asserted sovereignty of the Crown, because it's based on that doctrine of discovery. Because Canada is a settler state. It's really no different than what the government of South Africa was. The United States is a settler state. The Latin American governments, you know, they all came from European expansion. And as a settler state, you know, a sign of maturity is being able to deal with your indigenous peoples. Canada hasn't looked at the history. That's what's been talked about here. But that's no excuse, because the denial of our rights, Canadians benefit from. It's a subsidy. You're all benefiting from the government's policies. So you're complicit in the systemic and structural poverty that's been imposed on our people and is maintained on our people, saying, you know, if you want out of the Indian Act, we're going to let you become municipalities within Confederation. So we'll be at the bottom of Confederation. But in exchanging that, we have to give up our identities, our history, who we are, to become Canadians. Some have chosen to do it, but many are resisting and fighting it and saying that's not fair. But the problems are that going to court costs millions and millions of dollars to meet the legal tests that have been set out, you know, to assert Aboriginal rights and Aboriginal title or treaty rights. Bands don't have that kind of money. Most of their money comes from the federal government in terms of transfer payments, which have terms and conditions on them. You know, and they don't let you use money to take the government to court. So on the one hand, the court's laying these onerous burdens of proof onto First Nations that they can't meet. And on the other side, the federal government's saying, come on, we're ready to negotiate with you. And so hundreds of bands have gone into what I call termination tables. Because what they're going to terminate is their pre-existing rights for these small trickle-down rights that Canada's offering. And I don't buy that the James Bay Agreement and Nishka and all those are good models, like Roberta was saying. There's no empirical evidence that I've seen that says entering into a modern treaty improves your social and economic situation from being under the Indian Act and the existing program and service delivery structures that are there now. I mean, they're both setting out, you know, patterns of funding flows. But I know for a fact that within the James Bay Cree area, they still have a lot of problems, social problems, that haven't been addressed because of the agreement. And not everybody's working up there. And they got, you know, same problems a lot of other communities have with drug abuse and other things. So, you know, I think we need to come up with some effective criteria about what would be fair agreements, you know, that would be consistent with Section 35. Anyway, this termination plan, it's underway. Harper government speeded it up on September 4th last year when he announced a results-based approach to these 93 termination tables, as I call them. And those are tables across Canada that there's hundreds of bands at them, negotiating either comprehensive claims and or self-government agreements. And what this results-based approach is they're assessing each of those 93 tables to see if they're ready to settle under the existing terms of the policies. The tables that don't agree with extinguishment and, you know, terminating rights and becoming municipalities and paying taxes and accepting the 2 orders of federal provincial governments and all the things that go with it, they're going to drop those tables that don't want to do that. They're going to stop funding them. So they're using money to coerce or blackmail people into settling. That's the one voice that Chuck Straw's talking about. We want to hear you speak with one voice. It's okay, we surrender. I mean, that's the way I see it. That's how I interpret what he said. Because he said, we reached an agreement here and the neighboring band doesn't like it. And, well, maybe that neighboring band can read a little bit better than this one. Because that's the reality, you know. Anyway, I don't know more. They started opposing the suite of legislation affecting the Indian Act and the environment last fall, as you know. I think one of the triggers for it also was when the chiefs got into a scuffle in Parliament Hill, I think in early December. About the same time that Chief Spence, started her hunger strike and her demands for a meeting with the Governor General and the Prime Minister. And that led, to all the rallies and the political movement. I believe it's a political movement that started in November and January and right up till now. And we were meeting with the founders, the Defenders of the Land Network Organizing Committee. And we agreed to work together in an alliance because the Defenders of the Land is a land-based representing a network of Indigenous communities on the land and their non-Indigenous allies, Canadians. And we brought our experience in that to work together with the founders on dealing with the issues that the I Don't Know More founders and movement started to question the Harper government on. So we, in our alliance, in our Sovereignty Summer campaign, which can be more than just this summer, it could be every summer until we get our demands met. I'm going to read through them. I'm going to end off my presentation by reading through them to set the context for our alliance. Our first demand is to repeal provisions of Bill C-45. That was the one, which had some changes to the Indian Act, but it also changed the Navigable Waters Act in that. It says, including changes to the Indian Act and Navigable Waters Act, which infringe on environmental protections, Aboriginal and treaty rights, and abandon all pending legislation which does the same, because there's still bills before the House that haven't passed through yet. This one I'll attribute to I Don't Know More. This is one of their issues more than Defenders of the Land, but we agreed to support it. And that's deepening democracy in Canada through practices such as proportional representation and consultation on all legislation concerning collective rights and environmental protections, and include legislation which restricts corporate interests. Our third demand is in accordance with the United Nations Declaration on the Rights of Indigenous Peoples principle of free, prior, informed consent, respect the right of Indigenous peoples to say no to development on their territory. Number 4 is cease its policy of extinguishment of Aboriginal title and recognize and affirm Aboriginal title and rights as set out in Section 35 of Canada's Constitution and recommended by the Royal Commission on Aboriginal Peoples. 5 is honor the spirit and intent of the historic treaties, officially repudiate the racist doctrine of discovery and the doctrine of terra nullius, and abandon their use to justify the seizure of Indigenous lands and wealth. 6, our last one, actively restrict violence against women and hold a national inquiry into missing and murdered Indigenous women and girls, and involve Indigenous women in the design, decision-making, process, and implementation of this inquiry as a step toward initiating a comprehensive and coordinated national action plan. And I guess, just on that last one, I would note that the premiers, including Premier Wynne, all agreed with that. But, I would say it's easy for the premiers to say that because what's being called for is a federal inquiry. So they don't have the jurisdiction to do it. It's nice that they're doing it and adds, I think, a bit to some pressure, but the Harper government already said no to that. So I guess my last comment is Prime Minister Harper, since he got in, he had an ideological objective towards Aboriginal peoples and First Nations in particular. It's an adversarial one. I mean, he's fighting us on all fronts. He's refusing to give the Truth and Reconciliation to documents that they're asking for. He's fighting Cindy Blackstock on, the child care case, the gap in funding, between on-reserve students and children and off-reserve. He's trying to impose agreements under these termination tables and policies. On every front, I see him just fighting us, including, denying a national inquiry on murdered and missing women. So we're in a very serious situation. They're using legislation The courts are constricting the interpretation of Section 35. The policies are there the federal policies are there to undermine our rights. So we are in a colonial racist country, and Canada has to confront that, because if we're going to move past that towards any kind of reconciliation, we're going to have to deal with the past, which is still going on now, because these past policies are still present. And the stain on Canada's reputation is only going to get darker and wider and bigger, because many of us are going to go internationally and expose Canada for what they're doing to us, how unfair it is, and how it's not consistent with our human rights internationally as peoples, because we have rights as peoples internationally. And I guess I'll leave it there. So, thank you.
Thank you, Russ. Our second speaker is Arthur Manuel. He's also part of Defenders of the Land, an activist, and does a lot of work internationally with Indigenous sovereignty and Indigenous rights. So you can join us.
Thank you, Sheila. And, oh, here's your signs. First, I would like to acknowledge the people on whose territory that I have the privilege of being on, the people of Chippewa, of Rama. My name is Arthur Manuel, like she said, and I'm a former elected chief and former tribal chairman of this Secwepemc Nation, Shuswap Nation in south central interior of British Columbia. And my father was the late George Emanuel, who was former president of the National Indian Brotherhood before the AFN. And I just say that simply to preface that I do have some experience in this area a lot, because it's one of the areas where there isn't really a school that you can go to learn how to do the kind of work that we're trying to do to decolonize ourselves inside a state government is something that is very unique. Like Russ was talking about, the termination policy is a real policy that I grew up with. You know, my father, when I was just a young boy, just so high, asked me if I knew what assimilation was. Of course, I didn't know what it meant, and he said, assimilation is like when you have white sugar and you put it into a hot cup of tea. He said, what happens? And it disappears. And he says that's what the settlers are trying to do with us as Indigenous people. So I kind of sort of learned about politics at a fairly young age in that sense. I think one of the things that we need to understand is that groups like Idle No More are a consequence of a government that has been stonewalling Indigenous people from achieving freedom and achieving our full human rights as Indigenous people. You know, like it's been 82 years that the Kukuching has had conferences, but like to say this is the first time they're talking about Indigenous people. And you heard a former prime minister here talk about the poverty, and you heard our former national chief, Phil Fontaine, talk about this poverty. And it's really important to understand that the people who suffer this are suffering it this very minute, this very second, throughout all of Canada. And yet we're still sort of toying around, fooling around kind of on this issue, trying to figuring out what can we do as Indigenous people, what can we do as Canadians. And from this dialogue, where is it going? Obviously the government's not here, Harper's not here. Harper's in Ottawa. There's other plans and things happening from that level. And that kind of repression and oppression is felt by the community. And they're not satisfied with the establishment Indigenous organizations and what they're doing, like the elected chiefs, the chiefs assembled as the Assembly First Nations and the different organizations. That's what gives life to Idle No More, because they're dissatisfied with that. If they were satisfied, they wouldn't do anything. They just leave it up to those establishment organizations to carry on doing what they have already been doing, but they haven't been seeing any fundamental change in policy in terms of government, any fundamental change in their lives as impoverished people that would improve the quality of their life. They haven't seen that, so they're very upset. And I stand behind those people. I think that we need to create the kind of tension, not only here locally, but provincially or nationally, but also internationally, that will create the kind of change that we need to see. And I don't agree with incremental change. I think incremental change just drags it out longer. We need fundamental change. And when I mean fundamental change, I mean the difference between the existing policy of government of extinguishment and assimilation of Indigenous peoples as separate constitutional legal entities, as peoples. They must change from that extinguishment and assimilation to one of recognition and of coexistence. And that's a fundamental change. That's what I mean by fundamental. It's the exact opposite of what it is. And it's in the mind of the Prime Minister that change has to take place, and that's where the people have to have a political will to create that kind of change. But you don't see that in the form of government, because you see governments want to repress. And I just say people in Idle No More have to remember Ipperwash, because that's how forceful government will get in terms of trying to force their policies on Indigenous people, and how forceful they'll be to repress people, where they'll use armed forces in order to try and support their side of a competing legitimate proprietary interest between two groups. Sure, the province has an interest, but so do the Indigenous people have a legal interest. And they're saying we can show up with guys with guns and we can force you through injunctions, through using the RCMP, into jail if you don't abide by that. And that's where you lose your freedom as Indigenous people. You become intimidated by that system. And a lot of our leaders do get that way, but we need to remember that. I want to briefly go over two quick areas, one in economics and one in terms of human rights. One of the things that I did economically, and it's an international type story in the end, is when I was a chief in 1999, we went logging off the Indian Reserve, and the province put out a stop a work order and this kind of thing, stop work order against us, and we didn't abide by it. But we haven't been to court. This is since 1999, and we've been trying to get to court, and it's been 14 years, and we still haven't gone to court. And the reason we want to go to court is to contest them on Aboriginal title issues. But despite the fact that the federal government says that there's, I think, two options that we as Indigenous people can do in terms of trying to deal with our rights. One is to go to court or go to negotiate under that claims policy. I tell you, trying to go to court is not necessarily that easy either, because the province, British Columbia, is terrified to go to court because once Aboriginal title is found, it will oust provincial jurisdiction. Totally, the province wouldn't exist in terms of a province, and so that just totally terrifies them. So that's how come it's been so long that we've been 14 years. Our lawyer is Louise Mandel, so she's a quite prominent, and she knows how to get into court kind of lawyer, but she's had her problems in trying to get into court on this one. But anyways, the real story that I want to talk about, though, is what we did. And Nicole Chavez is here. She's one of our lawyers that worked with me on this issue. Was we also went to the World Trade Organization and to NAFTA, and in the Canada softwood lumber dispute, because it happened at about that same time. And quickly, the argument that we made before the WTO and NAFTA was that the Canadian government's policy of not recognizing Aboriginal and treaty rights was a subsidy to the Canadian forest industry. And that, we made 3 submissions to the WTO, and on all three occasions they accepted it. And when Canada brought their case before the NAFTA, we made a similar submission to NAFTA, and they accepted it, even though the Canadian government, the Ontario government, a bunch of the provinces, and the forest industry all hired lawyers, and they all fought against it being accepted. It still was accepted. That just means that in the respect to trees that were made into 2x4s and exported to the United States, what they're basically saying is that we as Indigenous people had to be paid as original owners of those trees. And because the government didn't pay us, the fact that they could sell the trees at less than fair market value, therefore it was unfair competition to the American logging companies, the lumbering company in the United States. I say this simply because you need to understand when you're talking about poverty, the money is there, It's really a political allocation made by government as to who gets what money from that 2x4. And what they try to say is Indians or Indigenous people should get absolutely nothing from that 2x4. That's Harper's decision. That's the Premier's decision. Those are the people who can make those decisions. We're the guys that are always left, at the welfare line, always left at the unemployment line, always left bumming around. Why? Because they do not want to deal with fairly sharing lands and resources that we actually own. That's what the underlying racism is all about. But, our decisions were accepted by one of the highest trade tribunals in the world. One of the highest trade tribunals of North America. So they can draw the connection, but the Ottawa, government can't accept that, nor can the provincial governments accept that. But definitely, Aboriginal and treaty rights is an economic risk. There's no and ifs and buts about it. They can the governments can either avoid them, accept them, reduce them, or transfer those risks. And those are the issues that we need to look at as Indigenous people and as Canadians to see whether or not we agree with that. One of the things that they're trying to do right now is to do resource revenue sharing. And part of that, I think, is in response to some of the stuff that we did on the softwood lumber, especially in British Columbia, because I know when we were had our first submission accepted by the World Trade Organization, we met with the United States Trade Representative at the United States Embassy in Geneva, Switzerland, not Geneva Conference Center. I mean the real Geneva. We met with them there, and their main interest was they would always ask these U.S. trade lawyers, you mean Canada never paid you 1 cent? 1 cent for your trees? And we'd say no. And then we'd start talking about something else. And then they'd go back to that. About 3 times they went back to that whole issue whether or not we were being paid. Because one of the arguments Canada was making was that they were making the argument that they weren't charging stumpage, they were charging a tax. But you can't charge tax unless you could sell the trees. And the biggest question against whether or not the province could actually transfer proprietary interest in those trees from the province to the timber company was the question of Aboriginal treaty rights. And so that was one of the reasons that they were dealing with that way. But one of the things I just want to say, though, in terms of resource revenue sharing, that you need to be careful with, and the government's trying to skirt around dealing with Aboriginal and treaty rights, is that if you accept resource revenue sharing under federal or provincial legislation, they do not necessarily recognize that you have Aboriginal treaty rights inside those agreements. And I've seen some of those agreements, they're trying to work against that. But before we carry on much, I just want to just quickly touch on this whole question of values in terms of Indigenous people when we're talking about economics. Because some people the other day were saying, well, the group that I represent is the Indigenous Network on Economies and Trade, and they were sort of thinking that I was sort of a person that was talking about economics in a sort of a microeconomic sense instead of the macroeconomic sense, because a macroeconomic sense is Aboriginal treaty rights. Microeconomics is running a mill or running a mining company or something like that. But on a macro-based level, you need to understand that Indigenous people have a fairly different value system than the Eurocentric economic system. In the Euro economic system, they look at land as a resource. It's a water resource, a mineral resource, a timber resource, forestry resource. They look at it that way, and they look at it as something like, how do you produce something? How do you consume something? And then how do you make profit? And then you produce garbage. That's a hierarchical system of economy. Indigenous people view economy quite different, where they look at water, plants, animals, the land itself, the air is all, and humans is all equal. And if you mess with one part of the circle, it's going to come back and mess with you sooner or later. So you need to be careful when you mess with the water, because you could be affecting the salmon, and that's going to come back and affect you, And so the whole concept of economy is different. And that's the part of economy that the Indigenous Network on Economies and Trade pushes. So we're not really pushing the Eurocentric concept of economy. Like the Eurocentric concept of economy, as far as I'm concerned, is it was good while it lasted economy, In BC, we know that in terms of forestry. At one time in my area in the interior of British Columbia, we had trees that were 4 feet across. They weren't just down the coast. Now they're logging trees this big. You know what I mean? That's what I mean. It was a good while it lasted economy. In terms of salmon, they're disappearing. And as long as the Department of Fisheries and Oceans for Canada is in charge of salmon, they are going to disappear. The only people that should be responsible for salmon should be the Indigenous people that eat the salmon. They're the ones that should be handling. Now I'd like to talk quickly about human rights. And some of the stuff sort of interfaces what Russ talked about. And I wanted to start off by just identifying colonizing and colonization, because that's a terminology that we need to become very familiar with. Colonization in Canada basically began with the British North America Act of 1867. That was an act by the Imperial Parliament of Great Britain. It was the first Constitution of Canada. And it turned over 100% access and benefit decisions in regards to our land to the federal and the provincial government. And that's what they're still trying to do. That's the minute the British North American Act was applied in our Aboriginal treaty territories in Canada, that immediately made Canada and the province rich, and it immediately made us poor. That's the source of colonization, is in that instance. And the Indian Act is a product of the British North America Act. It is an act to manage the poverty created by the British North America Act of 1867. That's what the whole bureaucracy of the Department of Indian Affairs is all about. That's how come they give young people in our reserve $168 a month on welfare. And they make them go and look for work in a town like Chase. You go to Chase, there's nobody from the reserve working at the Royal Bank, at the Thompson River Credit Union, or at the hardware store, or at the grocery store, or nowhere in that town are Native people working. It's not like the United States where they have affirmative action. They're forced to hire black people and Hispanic people and other people. You see that it's all mixed up at the Holiday Inn when you check in, you know. But in Canada and in Chase, you know, you don't talk to a Native person about anything in the store because you know they don't have a job there, you know. It just doesn't happen. Yet that town at one time used to be fed by the lumbering industry, but that's closed down. It used to be fed by the cattle industry, but that's all gone to hell. And there used to be funded by other sources. Right now it's funded by the three bands, you know, Nisconluth, Adams Lake, and Little Shoe Shop. Yet our young kids, they wouldn't trust them next to their cash register. You know, that's how much trust there is in that little town. But, you know, that's poverty for you. And the government has been pushing this whole question. They've been telling Indian people in British Columbia that Aboriginal title and rights is undefined. I think it's colonial doctrines of discovery that's undefined, because they're claimed to our territories because of David Thompson riding a canoe some 100 and some odd years ago, 300-400 years ago. I don't even remember how long ago, but he rode a canoe down there. They claim it because of Alexander Mackenzie and Captain Crook or Cook. Did you say Crook or Cook? And, you know, and Simon Fraser, you know, there's about 5 white guys they're claiming our land for. You know, that's pretty screwy. We're claiming our land because our people have been buried there for 10,000 years. You know, I think our title is more clear than their title, yet they're trying to say our title is unclear and ours is unclear and theirs is clear. So it's really bad. So because of that definition, they're talking about carrying on this business as usual. And they're doing business as usual, and they're trying to get us to do revenue sharing agreement, all these different kinds of things. You know, so we're not getting anywhere with Harper, and we're not getting anywhere with Christy Clark. You know, we need to decide where we want to get justice. Can we get justice inside Canada? I do not think so. We have to seek justice outside Canada, you know. And, you know, we do have the Declaration on the Rights of Indigenous People. It's a non-binding agreement, but it provides a window vis-a-vis that other 10 human rights treaties that the United Nations has signed. But it also is the first international, I guess, declaration repudiating the doctrines of colonial discovery. You know, it has done that. And it's important that we understand that. And it does recognize our right to self-determination. I think it should be clear that one of the international human rights treaties that Canada has signed is the International Covenant on Civil and Political Rights. And because they signed that, they're bound to implement those articles inside Canada. And one of the articles that they've signed is, one of the articles in the Covenant on Civil and Political Rights is the Article 1 on self-determination. And it talks about peoples, like the sign says up there, Indigenous peoples. You need to be, what does that really mean? Because what you put on your sign is a very political, international political statement. Because it embodies, like Article 1, subpoint 1, which is all peoples, it starts off with, have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. 2, that all peoples may for their own ends freely dispose of their natural wealth and resources without prejudice to any obligations arising out of the international economic cooperation based upon the principle of mutual benefit and international law. In no case may a people be deprived of its own means of subsistence. And Canada's bound by that, you know, and they're not implementing it. And the United Nations Human Rights Committee, I don't know if you know this, asks every country that signed on to the Covenant on Civil and Political Rights to appear before them every 5 years and provide a periodic report. And Canada has been asked in 2005, how are they implementing Article 1 in relationship to the Indigenous people of Canada? They were asked that question. But before I sort of deal with that, I just want to point out one of the clear points that has been recognized at the international level. And that has to go back to this issue of poverty. And it has to deal with Rudolphus Staffenhagen, who made an unofficial visit to Canada in 2003, and he made an official visit in 2004. And I think it's important to raise this because one of the things that he reported in September 2005 to the United Nations General Assembly was that he said, when I went to Canada, I need to note that there is persistent disparity between Aboriginal peoples and other Canadians. So you need to go back to self-determination and figure this through, and I'll walk you a little bit through that. Because one of the things that was interesting was the discussion that Russell raised was that 2% cap. And I think Scott Searson spoke to that too, the 2% cap. Is talking about the disparity, you know, the poverty. That's what it's talking about. The persistent disparity means the Indigenous people are, as a group, are impoverished. And persistent means it's created, a poverty that's created by the government, you know? It's not because of the individual. It's because all the land and resources for the Indigenous people have gone to the federal and provincial government. All decisions regarding land and resources goes to Ottawa or Toronto, Ottawa or Victoria, but it doesn't go to the local Indigenous people who actually own the land. All decisions regarding access and benefits to Aboriginal treaty territory is decided by some federal official or some provincial official under some law made by either Parliament or by the legislatures. And that's where the poverty is systematically created. against Indigenous people. It's part of that whole colonial doctrines of discovery. You know, for instance, British Columbia is larger than California, Oregon and Washington combined, but in the Indian reserves in British Columbia only represent 0.36% of the land. Not even 1%, 0.36%. And somebody was talking about Canada, it's actually only 2%, you know, of all the Indian reserves across Canada. That says, if you put that in the form of a loonie, that's the kind of money you would be getting out of that. That means they'll get, you know, 98% of it, and they'd be 99%, we'd give less than that. So that's the kind of thing that we need to talk about, you know, with the international community. You know, people need to realize that when people start putting 2% caps on your budget, they're violating your human rights. They're actually giving you greater power as Indigenous people to become more independent from the people that are oppressing you, the ones operating under 91, 92, you know. You know, when the United Nations Human Rights Committee in 2005, they asked Canada questions about how they were implementing Article 1 with regard to Indigenous people. And one of the issues that they raised was that Article 1 didn't define who is a peoples. Like when I read to you, it says all peoples are entitled to the right to self-determination. The real thing is that it doesn't say who peoples are. And so Canada is grappling with this issue when the Human Rights Committee asked them in 2005. And one of the things that they talked about was that there is such thing as Indigenous collectivities, but we don't really know that those Indigenous collectivities are actually Indigenous peoples. And so that's what they're arguing about. But this is what they said in paragraph 25 of one of the responses to the United Nations Human Rights Committee was, it said, the government of Canada believes that the understanding of the rights of self-determination is evolving to include the rights of groups living within existing states, which qualifies peoples under international law that respects the political, territorial, and constitutional integrity of the state. And it goes on to say that, and this is what they say about Indigenous people in Canada. They say, as well as in this traditional approach, Indigenous collectivities, peoples living within the existing state of Canada participate in the exercise of the right of self-determination as part of the people of Canada. Indigenous individuals in Canada benefit from all rights in the internal covenants. Canada has a government representative of the whole people belonging to the territory without distinction of any kind. So that's what they're trying to say, is that our right to self-determination is included inside Canada's, you know. Yet we're still the poorest. The other thing is, yet we're still the poorest people. It's sort of like we're saying, oh yeah, we love to be Canada. We love poverty. Just send us more poverty over here, you know. We really enjoy it, you know. One more generation, we'll just keep on going, you know. That's how stupid they sound, you know. But, you know, one of the things when they answered this in 2005 is it opened the door for us as Indigenous people to respond to this. And like they were supposed to appear in 2010, but they didn't appear in 2010. They're supposed to appear in 2015. That's when we need to be sure, like Idle No More and all these people make a special effort to be able to tell the United Nations Human Rights Committee about Canada's colonization, that the poverty is real, that Harper hasn't done one darn thing to change the record from previous generations and previous governments, you know. Because it's a real important to understand this, because James Onaya, the present special rapporteur for the United Nations, has been invited to Canada. and he'll be here in the last part of October, the last couple of weeks of October of this year. And I think it's really important if Canadians really make Canada's human rights record, bring it up to the front, because not only has the Human Rights Committee made recommendations to Canada regarding their violation of the rights of Indigenous people, but so has the committee that is responsible for economic, social, and cultural rights. So has the Committee for the Elimination of All Forms of Racial Discrimination. They have made recommendations. The United Nations has made a number of recommendations to Canada. Canada hasn't listened to one of them. Canadians should be totally embarrassed by the amount of response that the Canadian government has gotten. Those are the ways that people can really make change, I think, is to put pressure on them. Because you need to remember that the Human Rights Committee was the committee that got the Canadian government to change its position on sex discrimination against women under the Indian Act. They're also the ones that put pressure on the Canadian government on the distribution of property between women on Indian reserves. So Canada does respond to international pressure. Also, Canada changed its opinion on the UN Declaration on the Rights of Indigenous Peoples. So I don't think you should underestimate that the international forum is not a place that we as Indigenous people should go in our struggle. Anyways, thank you very much.